In this lecture, we shall discuss land and the various interests that can be held in land in Ghana. We shall discuss land and the various interests that can be held in land in the Republic of Ghana. Now, the main authority we shall use and rely on in this lecture is the Land Act of 2020, Act 1036. We shall look at the definition of land, and then we shall look at the various interests that can be held in land in Ghana. Now, it is important to identify the various interests in land because it is very common to see people and hear people saying that you own this land, I have bought this land. But to the lawyer and the legal practitioner, such a statement is not helpful in identifying what exactly has taken place. Because the right expression and most appropriate expression to use is to disclose the interests you have in the land, rather than saying that you just have bought the land or you own the land. So we shall begin first with the definition of land. And as far as the definition is concerned, we'll move straight to section 281 of the Land Act of 2020, Act 1036, to identify the definition that the Parliament of Ghana has given to land under the Land Act. So under section 281 of the Land Act of 2020, Act 1036, this is how the lawmaker has defined land, and I quote, "Land includes the solid surface of the earth, trees, plants, crops, and other vegetation, a part of the earth surface covered by water, any house, building, or structure whatsoever, and any interest or right in, to, or over immovable property." Now you realize that this definition of land under section 281 is even intended not to be exhaustive of what land is. Because the lawmaker begins by saying that land includes, and then he lists some items. The use of the word includes means that whatever follows there cannot be exhaustive as far as the definition of land is concerned. But the section 281 is nonetheless very, very helpful in giving us an idea of what land is. Because it tells us that it includes the solid surface, the trees, the plants, crops, other vegetation, part of the earth surface covered by water, any house, building, or structure whatsoever. So what are they telling us under section 281? That if you say you own this land and there are buildings on it, it means that you own the land and you own the buildings as well on the land. And that ownership or having an interest in the land would also include any building. They are all part of the land. And so if I have a 5-bedroom on a particular land, and I tell you that I own this land, I have an interest in this land, you should not expect me to tell you that I also have an interest in the house that is on the land, because the definition of land under section 281, it includes any house, building, or structure whatsoever on the land. Now, having defined land, the next question for the lawyer is to identify the categories of interests that can be held in land. You remember, I have already mentioned that it is very dangerous to just say that you own this land, because if you say you own this land, we may not be able to tell what exactly is the interest that you have in the land. And I've been mentioning interest in land. But what do we mean by interest in land? Now, the interpretation section of the Land Act of 2020, Act 1036, would also be helpful in this regard. Section 281 has a definition of an interest in land. And this is what it says, and I quote: interest in land means any rights or interest in or over land which is registrable under this act. Quote ends. You see, the lawmaker is telling you that the interest in land means any rights or interest in or over land which is registrable under this act. So it means that if you are going to register a land, what you go and register is an interest you have in the land. And you may not go and register your ownership. Like I said, that is why if I say if you go and register ownership, if you say ownership, I own the land, it may not be really helpful to the lawyer. Because if you say you own the land, we have not been able to disclose the interest that you have in the land. And so that is why Section 1 of the Land Act of 2020, Act 1036, is headed Interests in Land. Section 1 will list 6 interests that can be held in land in Ghana. 6 of them. It means that if you say that you are acquiring an interest in land, then it means that it must be one of these 6 interests that are mentioned under Section 1 of the Land Act 2020, Act 1036. So what are these 6 interests? Now, under Section 1 of the Land Act, we are told that the following are the interests in land. A, allodial title. B, customary law freehold. C, common law freehold. D, usufructuary interests. E, leasehold interests. F, customary tenancy. 6 of them. 1, allodial title. 2, customary law freehold. 3, common law freehold. D, usufructuary interest. E, leasehold interest. And then F, customary tenancy. Now, in order not to confuse you, I must at the outset make it clear that Act 1036, which is the Land Act, it does a distinction between interest in land and then registrable rights in land. So you see how Section 1 has listed 6 interests that are registrable under the Land Act. If you look at Section 81 of the Land Act, it is titled Registrable Interests. And interestingly, this is what Section 81 of the Land Act also says. And I quote, the interests in land which are registrable include A, allodial title. B, common law freehold. C, customary law freehold. D, usufructuary interest. E, leasehold interest. And F, customary tenancies. So you see, Section 1 lists the various interests in land, and Section 81 of the Land Act has identified these various interests as registrable interests. That is why it is important for you to note that it is very dangerous to say that I have bought this land. And the lawyer will not be able to tell what kind of interest you have acquired in it. But if you tell the lawyer that I have acquired a common law freehold, I have acquired a customary law freehold, then he knows that you have acquired a registrable interest in the land by the combined effects of Section 1 and Section 81 of the Land Act of 2020, Act 1036. Now, some people have wondered that if we say a definition of land means that the person who owns the land owns the building on it and everything on it, a question that has usually arisen is that if there's a building that has 8 stories on the building, and the story has 8 stories has about 20 flats. If I buy one flat, does that flat belong to me, or it belongs to the one who owns the land? How can I register an interest that I acquire in a flat that will be distinct from the person that has the interest in the land? On this issue, some people have argued that if you acquire an interest in a flat, you can't register it because you are not the one that has an interest in the bare land together with the building. And the one that has the interest in the bare land is the one that would also have interest in all the buildings and everything on it. That has been an argument people have made. But this problem has been addressed by Section 81, subsection 2 of the Land Act of 2020, Act 1036. It says that an interest in a condominium, an apartment, or a flat shall be registered in accordance with the regulations made under this Act. And subsection 3 explains the condominium to mean a single estate unit in a multi-unit development in which a person has both separate ownership and common interest with others. So it means that under the Land Act, we have made the registration of a single unit in the multi-unit development a registrable interest that can be registered in accordance with the regulations made under the Land Act of 2020, Act 1036. So now, please, if you want to identify the various interests we have in land in Ghana, Section 1 of the Land Act will be very helpful, and Section 81 of the Land Act is also very helpful in letting you know that there are 6 interests that you can have in land in Ghana. The allodial interest, the customary law freehold, the common law freehold, the usufructuary interest, the leasehold interest, and the customary tenancy. And on the first of Section 81, these are all registrable interests in land in Ghana. Now remember, I mentioned that there's a distinction between registrable interests and registrable rights. Now, even though the Act identifies 6 interests we can have in land in Ghana, the Act indicates that there can be 7 rights that are registrable under the Land Act. 7 rights. So the Act identifies 7 interests. Sorry, the Act identifies 6 interests and then 7 rights. So look at Section 82 of the Land Act of 2020, Act 1036. Section 82 reads as follows, and I quote, "The rights that are registrable in relation to land under this Act are," and they start with a mortgage, B, an easement, C, a restrictive covenant, D, profit appendary, E, power of attorney, F, contractual license, and G, a user rights under a certificate of allocation. So there are 7 of them. 1, a mortgage, 2, an easement. 3, a restrictive covenant. D, a profit appendary. That's 4. 5, power of attorney. 6, a contractual license. And then 7, a user right under a certificate of allocation. So 7 of them. 1, mortgage. 2, easement. 3, restrictive covenants. 4, profit appendary. 5, power of attorney. 6, contractual license. And 7, a user right under a certificate of allocation. So 7 rights that can be registered under the Land Act in Ghana. So if you have a question that asks you to discuss the various rights you can have in land in Ghana, and you go and discuss the interest, it means that you have totally deviated. You have totally deviated. So note that interest under the Land Act are different from rights that you have under the Land Act. So let us go back to the various interests, which is the subject matter of our present discussion, and identify and explain each of the various interests that we have in land in Ghana. So let us go back to Section 1 of the Land Act. And you remember, Section 1 identifies 6 interests. We'll list the 6 again, and we'll take each of them to explain. 1, the allodial title. 2, the common law freehold. 3, the customary law freehold. 4, the usufructuary interest. 5, the leasehold interest. And 6, the customary tenancy. So we shall begin with the first one, which is the allodial interest or the allodial title. What is the allodial title? Now, the allodial title has been explained in Section 2 of Act 1036. And this is how Section 2 of Act 1036 defines the allodial title. Section 2 says that allodial title is A, the highest or ultimate interest in land, and it is held by the state or a stool or skin or clan or family or an individual, and may have been acquired through compulsory acquisition, conquest, pioneer, discovery, and settlement, gifts, purchase, or agreements. So that is the definition of allodial title under Section 2 of Act 1036. Is the highest or ultimate interest in land. And Section 2 does a very good job by telling you where the allodial title may be located. That it may be located in either the state, the stool, or skin, or clan or family, or an individual. So Section 2 does not only define the allodial title, it's also very helpful in letting you know the categories of persons that can own and hold the allodial title. The state can hold the allodial title. A stool can hold the allodial title. A skin can hold the allodial title. A clan can hold the allodial title. A family can hold the allodial title. An individual can hold the allodial title. Not only does Section 2 tell us the categories of persons that own the allodial title, Section 2 also tells us the different modes by which the allodial title can be acquired. It says they may have been acquired through compulsory acquisition, through conquest, pioneer discovery, and settlement, gifts, purchase, or agreement. So Section 2 is very important as far as its statement about the allodial title is concerned. It doesn't only tell us the definition of the allodial title as the highest or ultimate interest. It tells us the categories of persons that can hold the allodial title. And it also gives us an indication about the modes through which the allodial title can be acquired. Now, there's a reason why I'm dwelling on this Section 2 as far as the allodial title is concerned. This is because prior to the coming into force of this Land Act of 2020 and 1036, there is this notorious case of Ohimin versus Ajay and another, which is reported in 1957 to West African Law Reports at page 275. And in this case, there was an extensive discussion about the principal modes through which the allodial title may be acquired. And I quote from the case as follows. Now, there are 4 principal methods by which a stool acquires land. They are conquest and subsequent settlement thereon, and cultivation by subject of the stool. There's discovery by hunters or pioneers of the stool of unoccupied land and subsequent settlement and use thereof by the stool and its subjects. That's number 2. Then gift to the stool. Then we also have purchase by the stool. That is what was held in Ohimin and Ajay. 4 principal methods: conquest, discovery, gift, and purchase. And this case was decided in 1957. 4 principal methods. So if today under Section 2 of our Land Act, we have gone above that one, and then we have compulsory acquisition as part of the modes of acquiring the allodial title, I must draw your attention to that. Because if you're going to rely on Ohimin and Ajay alone, you realize that it may not be too helpful for you in identifying the modes of acquiring the allodial title. So if you compare what is mentioned in Ohimin and Ajay, the 4 principal methods, if you compare that one to what we have under the Land Act, you will realize that the Land Act goes beyond what has been listed in Ohimin and Ajay. And I think they go hand in hand, because Ohimin and Ajay didn't say that the only methods of acquiring the allodial interest are those 4 ways. Ohimin and Ajay said the principal methods, meaning that they agree that there could be other methods of acquiring the allodial interest. So Ohimin and Ajay mentioned 4 principal methods. It didn't say 4 only methods. It said 4 principal. And the Land Act 2 has given us other ways too that it may be what? Acquired. So the Land Act pops up in Ohimin and Ajay and adds compulsory acquisition and adds agreements. Because Ohimin and Ajay, we have only conquest, discovery, gift, and purchase. But in the Land Act, we have all those 4, and we also have agreements, and we have compulsory acquisition. So in the Land Act, we are given 6 ways in which the allodial title may be acquired. Now, let me briefly comment about these 6 ways that have been listed under Section 2. Now, you realize that today, in this present day and age, nobody can go and say you have conquered somebody to take over their land. Traditional states do not go to war to conquer people. It will be criminal. These days, there are no ownerless lands in Ghana. So since there are no ownerless lands, you can't say you want to discover somebody's land, so you have taken over it. So conquest and discovery by hunters today may not be applicable because there are no ownerless lands in Ghana as we speak. And we will not allow you to go and conquer people, the Gans or the Ashantis or the Erbers, and say that you've conquered them and taken over their land. So conquest and discovery will be deemed to be old ways of acquiring the allodial title, but they are still important. Because you'll be surprised that there will be cases that are before our present courts. And then the people would have to prove their ownership by showing that their ancestors conquered a particular people before they acquired the land. So even though today you cannot acquire land by conquest, the knowledge that you can acquire the allodial interest by conquest is still very important for the lawyer. Because there are cases before the courts where people are tracing their ownership for 1,000 years ago to say that their ancestors are people who discovered the land. So even though I'm saying that they are no more practical today, conquest and discovery, I'm not saying they are no more relevant, because there are people who will have to rely on that to prove their ownership of their lands. But in present day Ghana, the present ways you can end up acquiring the allodial title will be gifts, purchase, agreement, and then compulsory acquisition. Compulsory acquisition. Those ones, they may still be applicable. Now, let me briefly give you an indication, even though we've already mentioned it, of the people that can hold the allodial title. Remember, Section 2 mentioned that it can be the state by compulsory acquisition. So if you look at Article 20 of our 1992 Constitution, it tells you that the state has the power to compulsorily acquire land and pay the people from whom they compulsorily acquire the land the appropriate compensation. So once the state compulsorily acquires land in the public interest, then the state will be deemed to have acquired the allodial title. They will not own any obligation to anybody again. So they have acquired the allodial title. In some books, we see this one being referred to as the eminence domain of the state. Eminence domain, the right of the state to compulsorily acquire land in the public interest. And then, if you come to the location of the allodial title in the stool, I refer you to look at the case of Jamestown Allata stool and another versus Sempe stool and another, reported in 1989-90, 2 Ghana law reports at page 393. Now, if you read this case and you look at the holding as captured in the head notes, this is what was said in the holding. And I quote, "The history of Jamestown showed clearly that it was constituted by 3 quarters, namely Akumaji, Allata, and Sempe, and that their property was vested in the Jamestown Manche. Each quarter could only claim ownership to an area which was in its exclusive possession. It would therefore be wrong for any one of the 3 stools to claim for itself the allodial title to all Jamestown lands." So, this case gives an indication that the allodial title can be located in the stool. So, authority for proposition that the allodial title can be located in the stool. Remember the case of Jamestown Allata stool and another, versus Sempe stool and another. Because it is in this case that the court held that the history of Jamestown showed clearly that it was constituted by 3 quarters, Akumaji, Allata, and Sempe, and their property was vested in the Jamestown Manche. Jamestown Manche is the chief of Jamestown. Jamestown Manche. And what the quarters could only do was only to claim ownership to an area which was in their exclusive possession. But those quarters can never claim to be the allodial titles of those lands that they're in their possession, because the person that has the allodial title to those lands is the Jamestown stool. If you want authority for the proposition that allodial title can be located in the stool, remember Jamestown Allata stool versus Sempe stool, 1989-90, 2 Ghana law report at page 393. And if you want authority for the position that the allodial title can be located in a family, for that, I refer you to the case of Amioda versus Pordia. Amioda versus Pordia and Amioda versus Forzi and others consolidated. Reported in 1967, Ghana law reports at page 479. In this case, Apalu JA at page 491 of the report said as follows, and I quote, "The lands in Ningo are not stool lands, but they are owned by families or quarters, and that the lands in dispute belong to the appellant's family." Quote ends. What I want you to note about the dictum of Apalu in Amioda versus Pordia is that the lands in Ningo are not two lands, but they are owned by families or quarters. It means that it is only the families that own the allodial title. And Ningo. So if you go to Ningo and a stool is about to sell land to you, to say they have the allodial title, remember Amioda and Pordia, that Ningo lands are not two lands and they are only family lands. This is telling you that the lands that the family can own the allodial title. And this position in Amioda and Pordia has been affirmed in the case of Pampam Paramount 2 versus Central University and two others. Suit number H1/19/2011 unreported. So Ningo lands are not two lands, they are family lands. And their families own the allodial title to Ningo lands. And if you want an authority for the possession that the allodial title can be vested in families, remember Amioda versus Pordia. But what about individuals? Is there any case that has affirmed that the allodial title can be vested in individuals? I refer you to the case of Nyasemhwe and another versus Afibi Esan. Nyasemhwe is spelled Nyaseemhwe. Nyasemhwe and another versus Afibi Esan. Afibi Esan is spelled AFIBIYESAN. Reported in 1977, one Ghana law report at page 27. Look at the holding one. You realize that the allodial title can be located in an individual. So we have said enough about allodial title. We know it's a registrable interest in land. We know that it's the highest or ultimate interest in land. We know how it can be acquired, as we've seen from Ohimin and Ejay and Section 2 of Act 1036. We've seen the persons in whom the allodial title can be located. So we've said enough about the allodial title. Now let's move on to the next registrable interest in land, which is the customary law freehold. The customary law freehold. This customary law freehold is also referred to in some books as the derivative title. Derivative title because it is derived out of the allodial title. But what is this customary law freehold? How do we define this customary law freehold? We refer to Section 3 of Act 1036. And this is what Section 3 says about the customary law freehold. The customary law freehold, and I'm quoting from Section 3 of Act 1036. Customary law freehold is an interest which arises from a transaction under customary law, and it is an absolute interest in land which is not subject to any proprietary obligation, but is subject to the jurisdictional and cultural rights of the stool or skin, or clan or family, which holds the allodial title. B, acquired when a person or group of persons, where the law permits, purchase land outright from the stool or skin or clan or family, which holds the allodial title, or acquired by gift or inheritance. And C is of perpetual duration and is inheritable and alienable without the consent of or payment to the stool or skin or clan or family. This is the definition of customary law freehold under Section 3 of our Land Act. And there are several interesting things to note about this definition that will make it easy for you to be able to distinguish this customary freehold from other interests in land. Now, these are the key things that you will note from the definition of the customary law freehold under Section 3. There are 6 key main things that I can summarize and let you know from Section 3. 1, we are told that the customary law freehold is an interest in land. Number 2, we are told that this interest in land must arise from a transaction. And examples of the transaction can be an outright purchase from the stool or skin. It can be a gift from the stool or skin or clan that holds the allodial title, or it can be through inheritance. So 1, we are saying that this customary freehold must be an interest in land. Number 2, this interest must arise from a transaction. And examples of the transaction are purchase, gift, or inheritance. Then number 3, this transaction must be a transaction under the customary law. It must be a transaction under what? The customary law. It means that it must be a transaction under the customary law. That is what can create the customary law freehold. It is important for you to note this. This is what will distinguish the customary freehold from the common law freehold. So please take note of it, that the transaction must be a transaction under the customary law. Then, number 4, defining characteristic of the customary freehold is that the holder of the customary law freehold is not subject to any proprietary obligations of the stool or skin or family, as the case may be. He doesn't owe any proprietary obligation. The moment you acquire the customary law freehold, you don't owe any proprietary obligation to the allodial title holder. You own the land forever. You can hold it in perpetuity. You don't owe them any proprietary obligation. And that's number 4. Number 5, the holder of the customary law freehold is subject to the jurisdictional and cultural rights of the stool or skin or clan or family which holds the allodial title. So you see that even though we are saying that you can acquire the customary law freehold, the holding of the customary law freehold, even though we are saying that you are not subject to any proprietary obligation of the stool, the law is that you are subject to the jurisdictional and cultural rights of the stool or skin or family which holds the allodial title. And then number 6 is that the holder of the customary law freehold holds it of perpetual duration, and it is inheritable. Perpetual duration, it means you can hold it forever. And it is also inheritable. You can pass it on to your descendants. It is also alienable. You can transfer it to people without seeking the consent of the holder, of the allodial title holder. So these are 6 key things that you must note that define the customary law freehold. The 1, it is an interest in land. This interest must arise from a transaction. This transaction must be a transaction under the customary law. The holder of the customary law freehold owes no proprietary obligations to the allodial title holder, and thus the holder of the customary law freehold only owes jurisdictional and cultural rights. It is only subject to the jurisdictional and cultural rights of the allodial title holder, and it's also of perpetual duration. 6 key things, and then they can make you easily identify and explain the customary law freehold. Having given these 6 things, I'll go back and read the definition of the customary law freehold under section 3, and you see how simplified it will now become. And once again, quoting section 3 of the Land Act of 2020 Act 1036, and this is what it says in defining customary law freehold. Customary law freehold is an interest which arises from a transaction under customary law, and it is an absolute interest in land which is not subject to any proprietary obligation, but is subject to the jurisdictional and cultural rights of the stew or skin or clan or family which holds the allodial title. B, is acquired when a person or group of persons, where the law permits, purchase land outright from the stew or skin or clan or family which holds the allodial title, or acquired by gift or inheritance. And C, it is of perpetual duration and is inheritable and inalienable, and it's inheritable and alienable without the consent of or payment to the stew or skin or clan or family. So you see why I said that now that you have the defining characteristics, the definition becomes very simplified. Because you see over there that it is still, you have the interest in land. This interest must arise from a transaction. This transaction must be a transaction under the customary law. Now, the holder is not subject to any proprietary obligations to the allodial title holder, but the holder is only subject to the jurisdictional and cultural rights of the allodial title holder, and the holder of the customary law freehold holds it of perpetual duration. It's inheritable, alienable, without the consent of the stew or skin. So that's for the customary law freehold. But remember that the 1969 Constitution prohibited the acquisition of customary law freehold by non-Ghanaians and any person in stew and skin lands. So the 1969 Constitution prescribed and prohibited that. So we are done with the customary law freehold. We are done with the allodial title. We are done with the customary law freehold. Now the third interest in land we have to look at is the common law freehold. The common law freehold. Now this common law freehold is one that we must take a lot of time to dissect, because we will realize that out of this common law freehold, we will be discussing the 3 different forms in which the common law freehold can arise. That we can have the fee simple, the fee tail, and the life estate. So we are going to take our time to discuss the different forms in which you can have the common law freehold. I believe at this point, you still remember that under the customary law freehold, we mentioned that it arises under a transaction under the customary law. And remember, I mentioned that that is one of the key things that will distinguish the customary law freehold from the common law freehold. So let's see how Section 4 defines the common law freehold. Section 4 reads as follows, and I quote: the common law freehold arises from a transaction to which the rules of law, generally known as common law, are applicable, and is of perpetual duration or for any other uncertain duration. B, subject to the interest of the state, the jurisdictional and cultural rights of the stew or skin or clan or family which holds the allodial title. C, is free from all obligations to any other person. And D is inheritable and alienable. It's inheritable and alienable. So once again, let us look at the key things we can know from this definition. Then we'll see how it can simplify the common law freehold to us. So the key points to note from the common law freehold. 1, it is an interest in land. 2, it arises from a transaction. 3, this transaction must be a transaction that is governed under the rules generally known as the common law. I believe now you see the defining characteristics. That under the customary law freehold, we said that it arises from a transaction under the customary law. But over here, we are told that it's an interest in land. It arises from a transaction. This transaction must be governed under the rules generally known as the common law. 4, it must be held free from all obligations to any other person. 5, it is subject to the jurisdictional and cultural rights of the stool, skin, or clan or family which hold another title. And then 6, it is of perpetual duration, it is inheritable, and it is alienable. So these are the defining characteristics of the common law freehold. If you can see, it shares the same characteristics as the customary law freehold. They are all of perpetual duration. They are all interest in land. They all arise from a transaction. Like I said, the only distinction that you will see over there is that one arises from a transaction under the common law, and the other arises from a transaction under the customary law. That is the common law freehold explained under section 4. But remember I mentioned that because this arises under a transaction under the common law, and the common law forms part of the laws of Ghana under Article 11 of our Constitution, we would have to identify the different categories of common law freehold that are even recognized under the common law. So under the common law, there are 3 types of freehold interests. And these are fee simple, fee tail, and life estates. So we'll take each of them and explain them one after the other. Fee simple, fee tail, and life estates. So I shall begin with the fee simple. Remember, we are still discussing the common law freehold. So I'm beginning with the fee simple. Now with this fee simple too, there can be 3 different categories of the fee simple. It can be fee simple absolute, fee simple determinable, and fee simple subject to a condition subsequent. Remember, I said that there are 3 different types of the freehold interest that you can have under the common law. That it can be fee simple, it can be fee tail, or it can be life estates. But the first category, fee simple, that one can be further divided into 3. Fee simple absolute, fee simple determinable, and fee simple subject to a condition subsequent. So let's begin with the fee simple absolute. For the fee simple absolute, it is held by the individual, and the individual has forever and ever without any conditions whatsoever attached to the land. So if you are the holder of the common law freehold and you have the fee simple absolute, it means that the land is vested in you, the individual, and your heirs forever and ever without any conditions. That is the fee simple absolute. You can transfer it, you can do whatever you want to do with the land, and there are no conditions attached whatsoever to it. That is fee simple absolute. Then we have fee simple determinable. Once again, this interest is also not constrained by time. It is one that is generally supposed to be held forever. Except that with this fee simple determinable, it usually comes with a condition that even though the holder of the interest is supposed to hold it forever, there is something that if it occurs, a condition that if it occurs, then the person holding the land will lose his interest in the land. And this is very simple to understand. Let me give you a clear example of a person who goes to the Registrable stool and tell the stool that they want to acquire a land forever for farming purposes. So you go and acquire a land solely for farming purposes, and they give you the land on the condition that you shall hold it forever, so long as you use it for farming purposes. It means that so long as you use the land for the farming purpose, you hold it forever. But the moment you change the use of the land and you begin to construct apartments, then that one, you can say that you will lose that interest. So generally, the fee simple determinable is supposed to be held forever, but it shall determine, it shall terminate, it shall end on the occurrence of a specified event. So if you want to hold it forever, do what you are supposed to do. But if you go and do what has been prescribed, then it means that the fee simple that you have will then end up terminating. That's the fee simple determinable. So we've dealt with two examples of the fee simple interest: fee simple absolute and fee simple determinable. The next category is fee simple subject to a condition subsequent. So this fee simple subject to a condition subsequent, it arises when under the common law, you go and acquire a land and you acquire a freehold. But even though you acquired the land for a freehold, a clause is inserted which gives the rights of the allodial owner to re-enter the land when you go ahead and you breach a particular condition of that particular conveyance. Now, the moment you breach that clause in the conveyance, then the allodial holder would have the right to terminate the conveyance and then exercise his right to re-enter. Now, I know over here, there may be some confusion about what then is the distinction between the fee simple determinable and the fee simple subject to a condition subsequent. Let me give you one defining distinction. One defining distinction is that for the fee simple determinable, the moment the event that you're not supposed to do occurs, automatically, the fee simple shall be deemed to have been terminated. But for the fee simple subject to a condition subsequent, there will be a clause that will say that the owner would have to now formally terminate the agreement before he can exercise the right to re-enter. And this is how the learned Sir Dennis Dominic Ejay, in his book Land Law, Taxes and Conveyancing in Ghana, 3rd edition, at page 14, this is how he identifies the distinction between the fee simple determinable and the fee simple subject to a condition subsequent. At page 14, the learned author says as follows, and I quote, "I am moving on to the second category of the common law freehold, which is the fee tail. This is very simple. This one usually arises where, let's say, you give a land to a person. Say you own a land, and you give the land to you own the land, and then you give a land to your wife. That upon your death, the land should go to your wife. And then after the death of your wife, it should go to your son. So if I have a land right now and I say that I am holding this land for my life, and upon my death, the land should go to my wife. Now, as it stands now, what I have in the land is what we call the life estate. And upon my death, the land goes to the person who has the fee title. So when I'm alive, I have the life estate. And my wife has the what? The fee title. So the fee title is basically an interest that is created by a lease or a will. And it will usually specify the persons who may inherit the property after the death of the grantor. That is what we call the fee title. So if you are aware that your dad has declared that he's holding the land for his life, and upon his death it is going to you, then what you have in the land is a fee title. And that's also a common law freehold. You have a fee title. So when you say fee title, we know that your rights are not accrued. But upon the death of the grantor, it will come to you. And you may now have it forever. That is the fee title. Then we have a life estate. A life estate is basically an interest in land that is limited to the life of the grantee or any other person specified by the grantors. So if you give a life to a person and they say that I gave this land to my son for his life, then all your son has in the land is a life interest. It means that so long as he's alive, he can have a right over the land. But upon his death, he will lose any interest he has in the land. So usually, if you have a life interest in land, then there's an obligation on you that you must keep the land in good condition so that when you are no more, it will go back to the one that is supposed to have the land. And also, if you have a life interest, you can also alienate the land. But whoever you alienate the land to, the day you die, the person too will lose any rights he has over the land. So that if I have a life interest in land, and I acquire the land from you today, and you give it to me for my life, and I sell it to somebody tomorrow, and I die the following day, it means the person will have only 1 day of enjoying the land. So when you give a land to a person for a life interest, the person holds the land only for his life. He can alienate it, but whoever he shall alienate it to will have it only for the lifetime of the one that the land was given to. And that is what we call the life interest. So if it was given to me for my life, it is my life that will determine how long my grantee will hold the land for. So these are the 3 different categories of interest that can arise at the common law. We have the fee simple, the fee title, and the life estates. So what we have done so far in this lecture is to look at 3 different categories of interest that have been mentioned under Section 1 of the Land Act. We have looked at the allodial title, we have looked at the customary law freehold, and we have looked at the common law freehold. As we mentioned, there are 6 interests that are mentioned under Section 1. So having dealt with the first 3 in this lecture, in our next lecture, we shall deal with the next 3 interests that have been mentioned under Section 1 of the Land Act at 1036. And the remaining 3 interests we shall look at in our next lecture are the usufructuary interests, the leasehold interest, and customary tenancies. They shall be the subject of our next lecture. So in this lecture, we have limited our discussion to 3: allodial title, common law freehold, and customary law freehold. Thank you.